going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Jedi. How's everybody doing tonight? I hope everybody is having a great day so far. It's Thursday, which means it's Friday Eve. It is Thursday, right? Hopefully it's Thursday. I think it's Thursday. So anyway, why am I here? I'm pinch hitting tonight, so we're going to bring up some good friends of mine that are sitting backstage. So welcome, Tharina
Hey, hey, hey.
and Sparkle Poots.
Hello.
Hello. We have hijacked once again. So here we are. Okay, here we go. Now I'm figuring out the the views here in StreamYard. Don't mind me. It's like, what is this? The first time I've done this? All right. So, here we are. I have no idea what's on the video. We're gonna find out. So
It's the best
we're
kind.
we're gonna do this on the fly, and it's gonna be awesome because we're all here for the community, right?
Yes, we are.
So, with all that said, I know, Therina, not to put you on the spot, but you are sort of designated as our personal flight attendant. So maybe you have some things that people should do or remember as we get situated here.
Whew, okay, here we go. Ladies and gentlemen, thank you for flying with Coolin' with Colin. Before we proceed with the stream, I'd like to remind you to hit like, hit subscribe, turn on reminders so that you get all your notifications, share the video, and enjoy the stream. We will be departing in approximately no seconds. Thank you.
Love it. You're so good at that.
Really?
And right off the bat, legal fiction coming in
Hey,
hot.
hey, making it rain.
Woohoo! 10 Kotlin memberships. That's awesome. Thank you, Legal Fiction. That's very generous of you, and we appreciate it. Um, and so, for everybody else, let's get going. I mean, I haven't seen Cheshire Cat, but we got to see if that credit card's still working.
Ooh,
So
yeah.
we'll have to find out. So all right. Well, thanks everyone for hanging with us tonight. And who wants to watch some court?
I'll watch some
I
court.
do. I do.
Okay, awesome. So let's watch some court.
Woo.
Here we go.
Yes. Okay, so let's go on the record in the matter of the City of Wyandotte versus Abigail Voluminous, 25892 A and B. Appearance for the people, please.
Good morning, Your Honor. Catherine Kuzmiak, D 85417 for the people.
Good afternoon, Your Honor. William Mays on behalf of Ms. Mullenless, stand and say your name, please.
Abigail Baldwin.
Okay, thank you. Although you're all switched, but that's okay. I'll just remember the prosecution today. Okay. So a couple things. First is the motion regarding, Mr. Mays filed two motions. One, motion to compel discovery, motion for dismissal without prejudice upon noncompliance, and motion to strike all undisclosed discovery. The court has reviewed the motion as well as the response. The court also, received a motion, or maybe it was a memorandum only regarding the right to remain silent and remain in a pretrial release hearing. And so, we can take the motion to compel first. And, the court did review the motion and the response. I'm not sure that there's a need for additional oral argument. Is there a need for any additional oral argument, counsel?
Yeah, I think so, Judge.
Okay.
So the prosecutor states that they complied with the discovery rule 6.201 by submitting a proposed discovery order. submitting a proposed discovery order does not satisfy their obligations under the discovery rules. They're required to produce. And they haven't. So the order that I specifically pointed out why the order is defective in my pleadings in section 2, asking for these photographic lineups and whatnot, like the usual suspects where people are standing up against the wall. None of this is even applicable. I mean, the facts are that they're required under the court rule to provide access.
Biggin, thanks so much for the raid. Welcome, Biggin Raiders. Please make sure to hit the like on your way in. So thank you for joining us today. And hello, Mrs. Biggin. I know it's not Colin, but I'll have to do for now. So thank you very much for the raid. We appreciate it. And oh no, Cheshire's card was declined. Thank you, Rich, for £2, two English British pounds. I don't know. I don't think it was declined. We might need to have somebody else check.
Are you sure you typed the number right?
Right. So for our raiders, we literally just got started. I don't even know what this case is about at this point. But we are just getting going here, so you haven't really missed anything. We are in Judge DeSanto's court, that much I can tell you. And there's been talking about complying with court rules, and that's where we are. Oh, legal found it.
Oh,
You got to use the PIN number. That's it.
yeah.
So,
Thanks for clearing that up, legal.
right, exactly. Thank you, Legal Fiction. We appreciate it. Oh, wait. Oh, MB says that's working for her too. Okay. Well, good.
You know what?
That's awesome.
I bet Rich has the old card number that Cheshire had
Could be.
replaced. That's got to be it.
Yep.
Yep. That could be it. Well, thank you, MB. We appreciate it. And I'm sure Cheshire does too. Is he even here? I haven't seen him, but I'm also trying to keep up with what's going on in the video so far since I don't know. Where's Colin? Not here. So that's all you're gonna get. He had something come up, so I'm pinch hitting. So that's what we're doing.
Like I told Hitchbot, girls came to play. That's all.
Yeah, exactly. So, and thank you, Cheryl. It's nice to see you. Cheshire still has hidden cash in his wallet. Oh, that's his first mistake, carrying cash around. Oh my goodness. Uncle Dan. What?
That's gold.
But tell me at least he did you at least give him a fiddle so that he could at least, try to duel with the devil on the fiddle and see how that one goes?
Yeah.
I mean, I know Cheshire's in Alabama and not Georgia, but we should make it work. Yeah.
Close, depending on where in Alabama you can spit and hit Georgia. So
right, exactly.
Yeah.
So we'll go with that. All right. All right. Thank you, Uncle Dan. Appreciate it.
Thank you, everyone.
All right. Let's keep going.
Not just access, but actually produce specific things under A when the defense triggers reciprocal discovery, and B is automatic. I mean, B, they just simply have to give it upon request.
Okay, so here's a question I have in reviewing this. When the defense triggers 6.201A, correct?
Yeah.
Okay. And so at what point does defense trigger MCR 6.201A? Is that upon filing a motion?
No. When the defense submits a demand for discovery under 6.201A, that triggers the reciprocal discovery. Now,
okay, hold on. You only quoted MCR 6.201. You didn't specify A or B.
I've detailed both A and B in the motion.
I understand that. In your, I understand that you detailed both A and B, but in reviewing your demand for discovery, you simply said 6.201 and you referenced 6.201V1 in your demand for discovery. And so I'm just asking based upon that, when 6.201A is triggered.
Yeah, that's with the demand for curriculum vitae and expert witness reports in the discovery demand.
So that triggers, that your argument is that triggers 6.201A.
Well, I mean, it's not included in 6.201B. And I have requested the curriculum vitae and expert witness reports from the prosecution.
Okay, and so why then is dismissal the appropriate remedy? And are you on your phone, counsel?
I've got my motion pulled.
Okay,
Dismissal is the appropriate remedy under 6.201J. If they're refusing to provide access, or if they're refusing to turn over discovery, then the appropriate sanction is under 6.201J.
okay. And has there been any sort of indication to you from the people that they are refusing to turn over any discovery?
That they haven't provided the discovery.
No, I understand they haven't provided the discovery based upon your,
I'm sorry.
based upon your motion. My question is, has there been any indication that they are refusing to give you any discovery?
Yes. You see, they have 21 days in which to get that discovery to the defense. They didn't.
Well, while they're paused, C-Dubs, thanks for the super chat. Found this in Cheshire Cat's wallet, so sending us the late and cat stepping on the keyboard fee. Very funny. Thank you, C-Dubs. Appreciate it. And I'm not able to pin links because I'm not in the YouTube studio, but I also did post, since he's not here, Colin's Linktree, which does have like PayPal and Venmo, which are commission free. Oh, did I miss the super chat, Dan? I'm sorry. Oh, here we go. Sorry about that. Let me bring that up. Thank you for the reminder, Dan.
Yeah.
Oh,
We
so many.
appreciate you reminding us to call you out.
Yes. Okay. You gave him an accordion. Turns out that earned Cheshire Cat a trip to the ninth circle. Sorry, friend. That is hilarious. Thank you, Uncle Dan.
Oh, Cat, no. No, don't eat your own router.
No.
No, that's not fun.
Oh, bad
Ugh.
kitty.
Bad kitty.
Oh, and then from me,
Oh,
Cheshire Cat, you did say you had no debt, so just trying to help.
thank you so much, Jedi, for that super chat. We appreciate it.
Right on. All righty, let's keep going here.
Okay, and Ms. Kuzmiak?
Yes, Your Honor. I would say that the people have been in full compliance with the Michigan court rules. We have provided defense counsel on not one, but two occasions with a proposed order for entry of discovery to allow him to have full access to all discovery materials that he would be looking for. In discussions with any curriculum vitae or any other expert reports, I have also been in discussion with the Michigan State Police to be able to provide him with those reports. So, your people's position, Your Honor, would be that we have provided the defense with, access to any discovery materials that he is looking for.
Okay, what, in review of the court rule 6.610E, right, that appears to have been amended to address the defendant's duty to disclose and provide certain discovery as well, which is more of a mutuality of discovery. It also required that discovery was mandatory in misdemeanor cases and not discretionary. It wasn't meant to address the other issue that counsel has stated that it must be supplied without cost, because I know that that's another issue that's, that needs to be addressed. So, and specifically, Mr. Mays referenced the comment to the amendment, and that comment specifically, the staff comment to the 2020 amendment indicates the amendment of MCR 6.610 allows discovery and misdemeanor proceedings in the district court by creating a structure similar to the federal rules, Federal Rule of Criminal Procedure 16B, in which a defendant's duty to provide certain discovery is triggered only if defense counsel first requests discovery from the prosecution and the prosecution complies. So the court, based upon that comment as well, the staff comment as well regarding the amendment and the purpose of the amendment, does not find that dismissal is the appropriate remedy in this matter. So the court's not going to dismiss this matter. The court does not find the people are not intending to produce the discovery. And further, the court will note that under MCR 6.201J, the court has discretion as to what any remedy would be. And so the Mr. Mays, have you been, I know that you indicated the curriculum vitae and some other general requests that you have made regarding individuals. Have you identified the individuals that you are requiring or requesting the curriculum vitae of?
Oh, no, it's whatever experts they have. I
Okay.
don't name their experts.
Okay, so at this time, has there been any indication that there is an expert that has been identified by the prosecution?
I don't know. Let me take a quick look.
No, there hasn't been, Your Honor.
Okay,
Sparkle Poots, Mima, thank you for the $5 super chat. I think I snapped something on the jump kick backflip. Ow. Well,
Don't do that.
what I think of when you say that is my snap was all over the place.
Oh my God, the bend and snap works every time.
It's court related, right?
Well, yeah, it's legally blonde.
Right, exactly.
Well,
Thanks,
I think-
Mima.
Well, oh, well, of course, it's going to a brilliant cause. I probably need to try it without the walker next time.
Yeah,
Oh yeah, yeah,
Yeah,
that
that'll
goes
get in
over
your
the
way.
bars. Yeah,
Yeah.
yeah,
yeah.
yep, definitely.
Got it.
Yeah,
Got it.
Found the
good
problem.
note for next time.
After round, found out.
Right.
Huh?
Your phones are supposed to be turned off and or
all right, and so, Mr. Mays, you don't like, you object to the people's, proposed discovery order. Do you have a discovery order that you, would agree with, or that you would prefer to, present to the court?
No, there's no order required. I'm attached, and you'll find in the file an order compelling production because of the non-production so far. But no, a general discovery order, I detailed this in section 2 of my brief.
I'm aware of that.
And this is,
Counsel, I'm aware of that.
okay,
I'm aware of that. You referenced that the proposed order that the people, put forth that you objected to.
yes.
So I was simply asking if you had a discovery order that you would prefer entered that comported with what you think it should look like, or not look like, but should be more representative of the current landscape of the court.
I mean, you mean in general for other cases or for this case?
For this case,
For this case, the order compelling production is appropriate. And in that, it states that if, they've got another 14 days under that proposed order, which I attached and submitted to the prosecution, that if they don't get me this discovery in the next 14 days, then the case should be dismissed without prejudice, but dismissed if they don't get it within 14 days.
Why?
Just like any other order compelling discovery would normally say, giving them some time to produce these materials, because I don't want to be unreasonable. But, in order in general, though, what they're proposing to enter an order, or what they might enter in every case, with their pre-signed signature, completely unnecessary. That is not anticipated by the court rules. And I've actually spoken to Josh Blanchard, who was one of the people that was very hands-on informative in terms of getting this new rule adopted by the Michigan Supreme Court. Doesn't anticipate an order. These old orders that we used to use were in lieu of a discovery order in the Michigan court rules. And the proposed order that's being used, being modeled on an old Detroit Reporters Court order.
first of all, counsel,
No longer.
as far as trying to make any sort of reference as to what it may try to look like or whatnot, that's irrelevant as far as the current discovery order that you are objecting to. So let's be very clear here. You want, let's say, your order compelling discovery. You want the prosecution to produce discovery requested in your demand for discovery. Your demand for discovery states that any exculpatory information or evidence known to the prosecuting attorney, any police report concerning the case, except so much of the report as concerns a continuing investigation, any written or recorded statements by Ms. Voluminous, a co-defendant or accomplice, even if that person is not a prospective witness at trial, any affidavit, warrant, and return pertaining to a search or seizure in connection with the case, any plea agreement, grant of immunity, or other agreement for testimony in connection with the case, the names and addresses of all lay and expert witnesses whom the prosecuting attorney intends to call at trial, any written or recorded statement by a lay witness whom the prosecuting attorney intends to call at trial, including all 911 recordings, videos, or other audio recordings, the curriculum vitae of any expert the prosecutor may call at trial, in either a report by the expert or a written description of the substance of the proposed testimony of the expert's opinion, the underlying basis of that opinion. In blood testing case, the request specifically includes a request for the full litigation packet, including all sample prep, chain of custody, standards, controls, and data pertaining to the underlying GC-FID, GC/MS, and or LC/MS/MS documents pertaining to blood analysis that provides a basis for the expert's opinion, as well as notes, printouts, and copies of the complete run, identifying the specific device used and employing this maintenance records. Any criminal record the prosecuting attorney intends to use at trial to impeach a witness, any document, photograph, or other paper that the prosecuting attorney intends to introduce at trial, including all video and or audio recordings, including body cams, in-car cameras, and booking videos, and a description of and an opportunity to inspect any tangible physical evidence that the prosecuting attorney intends to introduce at trial, including all expert witness materials that might be introduced pursuant to MRE 703, and in all blood testing case release of the second sealed blood sample to Ms. Voluminous's independent laboratory for independent testing by a qualified forensic laboratory. That's everything that you are requiring the prosecution to produce within 14 days.
Okay, whatever. I don't know what she just said. Oh my God, Judge. She just like read that thing so fast. I have no idea. But ladies,
Madam.
say it with me.
Bliss.
Hi, Rob.
Rob.
Oh, y'all so bad.
Oh, Rob.
I wasn't gonna do anything. I wasn't gonna say nothing, and now y'all done embarrassed him.
Pooch Robbie is here.
Yeah.
I had to. I had to. All right.
Hi, Bob.
So, bless their hearts.
Aw.
Aw. Aw. Rob or Dan, can one of you guys decipher what she just said? Because I have no idea. And I'm trying to keep up with what's going on here in this case, but it sounds like they're trying to get discovery, and for whatever reason, I don't know, they were talking about resumes or CVs, and it's like, what? I don't know. I don't know what's going on. Standard blanket discovery request. Okay. So
And that
all
translates
right.
to,
Lots of words were read.
okay.
So
I'm going to take it as Rob typed it as a standard blanked discovery request because
okay.
we got talking. I literally kind of blanked out on what she was saying.
I know. My eyes glazed over.
You called it, Rob.
All right, let's keep
okay.
going.
He goes on to say it lists anything the prosecution
Yeah.
may use to establish guilt. Okay.
Yeah.
That makes sense. That's Judge, say that.
Right. Yeah, just say those words.
Just say those words.
Or these words. Give me every damn thing.
Yes. 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 Plain English.
Right. And thanks, Java. Always on the flow chart.
Oh.
Getting that blanket on there. Perfect. All right. Let's keep going.
The order that has been submitted states, this matter having come before the court upon defendant's motion to compel discovery and for dismissal without prejudice upon noncompliance, and the court being advised in the premises, now therefore, it is hereby ordered and adjudged that the prosecuting attorney shall produce discovery requested in defendant's demand for discovery within 14 days of entry of this order.
Right, counsel,
That's all. And then
I have the order here. And I just read your demand for discovery.
So you're saying that you're reading the demand for discovery.
Correct, because that is what you're referencing in
I
the
got you.
order that you want this court to sign. So
Yes.
my question is this, you want all of this information produced within 14 days? Is that
Judge,
is that what you're asking?
yeah,
Okay,
you
And
raised
so-
your voice at me on 9/24 at our last hearing at the arraignment and asked me why I didn't have discovery yet.
Oh, he did not just say you raised your voice at me?
Right?
Ooh,
Sir,
bold strategy.
let's see how it works for him.
Right.
I got a feeling I know how.
Legal fiction. It puts the discovery in the basket.
It gives discovery again, or it gets the hose again.
All right. Yeah. So,
His heart.
yeah, bless his heart for
heart.
sure.
Bless it so hard.
Well, let's see how that strategy pays off for him, shall
All
we?
right, let's see.
Yeah, I'm
I said,
anxious.
why haven't you filed a motion to
No.
compel yet?
Nope. That is, first of all, that is not what I said. What I said is because you were objecting to the motion or to the order of discovery that Ms. Kuzmiak put forth. And then I said, if you're objecting to the order that's put forth, you can file a motion. That is what I said. I didn't yell at you because you didn't file a motion to compel. I'm not ordering you what to file. You were objecting to the discovery order as proposed by the prosecution. So my question is this. Everything that I just read on the record in your demand for discovery is what you want within 14 days.
Yes,
Okay. Whether or not some of this is known to the prosecution or not.
yes.
And if the prosecution does not produce something that's not known to them within the 14 days that you want it produced, then you think that the appropriate remedy is for dismissal without prejudice.
No, obviously, if they don't know about it, they're under a continuing duty to disclose thereafter.
All right, your response, Ms. Kuzmiak?
Your Honor, I would respond that, as I said before, discovery has been readily available to the defense counsel since I provided him with the first order for discovery, I believe the end of August, and then again, end of September. And discovery is readily available to be disclosed to the defense counsel.
In what respect is it readily available?
in the respect of the usual course of business in this court, that he should have a discovery order entered by this court, and then he can go to serve the order on the records department, and they will be happy to provide him with all the discovery that we have available to us.
Okay, and so, Mr. Mays, it doesn't sound as though, discovery is being denied in this.
I'm sorry, I was focusing more on the part where I take the order, they're proposing an order that they want me to agree to, that you will then sign, and then they will hand it to me, and I'm required to go to their police department, serve them with this order, and then I assume like give them processing time, maybe drive back and beg the police to give me whatever it is that the police will give me as detailed in my motion and brief, that this is totally not anticipated by the court rules. It is the prosecutor discovery on the defense, not to give them a piece of paper that gives me permission to go to the police department to ask them, may I please have discovery, and then have the police department, because also I'm anticipating, to give me an invoice to say, this is what you have to pay us before we'll give it to you, Mr. Mays. No, this is not FOIA. This is not a subpoena. I'm not required to serve the prosecution with a demand for discovery and then turn around and serve the I think she called it a records clerk. I don't want to have anything to do with the police. If I wanted to have something to do with the police, I would issue a subpoena, or I would issue a Freedom of Information Act. I'm not. I'm asking for discovery under the Michigan court rules, which requires the prosecutor to coordinate with its law enforcement partners, consistent with, the United States Supreme Court case that I've got detailed in my motion, Kyles versus Whitley, where they're required to coordinate with their law enforcement partners and turn over the discovery to the defense. There's nothing in there where the defense attorney is personally driving around to serve various parties to get their information that ought to be disclosed by the prosecution.
Your Honor, if I may, the people are not requiring defense counsel to drive around to various locations to locate discovery. Discovery is readily available upstairs in this courtroom. And also as to the cost of discovery, there is nothing in the Michigan court rules that provides that the prosecution bear the cost of discovery, and that if cost is of a question, that, defense counsel can have a hearing and it can be resolved in this court as to cost, but there is not one thing in the Michigan court rules that states that we bear the cost of discovery.
Okay, the court wanted to clarify, it's not the upstairs of the courtroom. It's
Upstairs,
it's the building which the court is in, yes, correct.
my apologies.
That's okay, I just wanted the record to be clear. Mr. Mays, was that a cough that you had?
I didn't say anything.
I know that. Ms. Kuzniak was speaking and there was a noise, so I didn't know if that was a cough.
You didn't say anything or make any noise.
Okay. And Mr. Mays, as it relates to the well, I'm sorry, Ms. Kuzniak, do you know what the procedure is regarding discovery within the Wyandotte Police Department from your request?
I'm sorry, Your Honor, could you elaborate? Do you mean the procedure as far as the defense counsel,
Yes,
when they present the order to the police department?
yes.
And if I could just touch on, I believe, the defense counsel would locate the records department at the Wyandotte Police Department and provide the records clerk with his order for entry of discovery. And depending on what, the defense counsel is requesting, the records department would, provide a delivery time and, most likely a fee for the discovery and be able to deliver the discovery to the defense, when it is available.
Okay, so Ms. Kuzmiak, as it relates to MCR 6.201B, where it indicates upon request, the prosecuting attorney must provide each defendant any exculpatory information or evidence known to the prosecuting attorney, any police report and interrogation records concerning the case, et cetera, continues to go on through number 5. And the prosecuting attorney must provide that. Why would the defense have to go to the police department themselves?
Your Honor, it's the usual course of business in this court. If the defense,
Like, why is he making such a big deal about having to go get the discovery? Like, isn't that your
Yeah.
job?
And
Or
so,
do you want everything handed to you?
well, and he wants it handed to him. What I'm lost on, so is he asking the prosecutor's office to obtain discovery that they were not going to obtain in the first place, and that they bear the expense and the time and the effort of getting it to be able to provide it to him, even though they were never going to use it to begin with? Did I miss something, or is that what he's asking for?
All right,
It
really?
might be.
Because that's what I kind of thought he was saying, because why else wouldn't they already have it to give to him?
Right.
And it's like, okay, no. Okay, Rob said yes. I'm hoping he's answering my question on that one. So, yeah, if they were never intending to use it, meaning that they never even had it, he wants them to now pay for it and to get it and to give it to him, even though they were never going to get it in the first. And that's just some BS.
Who? Jesus, are you kidding?
Yeah, that's bull.
All
Okay,
right.
so if
So
I
we
wanna,
got yeah.
Yeah.
So all right, so if Rob wants all of the officers' training records, then and the prosecution wasn't going to introduce that,
mhm.
he is entitled to it. But need to pay for the production of it.
Yeah, so you can go get it if you want it, but you would have to pay for it. And
Right.
this defense guy is like, no, I'm not going to pay for it and get it. They need to. And they need to give it to me because I asked for it.
Right.
Yeah, give it to me.
Yeah. Yeah.
Yes.
Give it
And
to
I said
me
it
right now.
I said it that way on purpose. He sounds like an insolent child doing this.
Right. Yeah.
He really does. I'm sorry, but I'm going to rename him to Violet Beauregard because, but Daddy, I want it now. No,
Right.
no, child. Like you said, Poots, he needs his passy and a timeout.
Yeah, that's just some people just make me nuts.
Yeah. It's my discovery and I want it now. Sorry.
Yeah, I don't care whether you need it or not, but you need to pay to give it to me.
Right.
And you need to deliver it to me too, because I don't want to have to go all the way to the police station.
I might work up a sweat, and that's not nice.
No.
Yeah.
No.
Yeah.
Yeah. No.
Well, someone should get this guy Snickers.
He really should.
And Kit Kat and whatever else we've said he needs, like
he's just not him when he's hungry. Yeah.
No, this Java puppy, no, this guy's not worthy to use Cheshire Cat's cards.
No.
Those are for us only.
Yeah. I'm sorry, but I'm not going to reward misbehaving children.
Right.
Yes. I reward positive behavior, not negative.
All right, let's keep going.
All right.
Counsel would rather have me provide him with what the police department is able to provide him. I'm able to do so.
And so, Mr. Mays, why you're indicating that that there should not be a cost associated with that?
Well, I'm not saying that there's never costs affiliated with production of materials under 6.201A. Under A6, there is a cost provision whereby either party, if they're encountering unexpected costs, that they may file a motion with the court addressing what's the appropriate division of fee splitting for some particularly expensive or cost prohibitive item. But the prosecution starts by saying, we charge for discovery in all cases unless the attorney is court appointed. That is not anticipated by the court rules. 15.234 under FOIA, MCL 15.234 has a cost generating device for Freedom of Information Acts. There is no similar analogous provision under Michigan law that allows prosecutors to charge for discovery. No statute. There is, however, 769.1F and 769.1K that allows them to cost recoup upon a successful prosecution for the cost of prosecution for the prosecutors and for the cost reimbursement to police. But generally speaking, taxpayers are already paying police to police and prosecutors to prosecute. When you become a prosecutor, you know that one of your mandatory functions as a matter of due process under Brady and Youngblood is you're going to provide discovery to the defense. That's part and parcel of being a prosecutor. So, but in those rare instances where there is an unexpected cost, yes, there is a cost sharing provision under 6.201A6, but not just generally for everything under 6.201A, and certainly not for materials under 6.201B. And it requires a motion, just like under People versus Jack. If they want to redact something from a police report, the prosecutor's required, at least under current law, to file a motion authorizing those redactions or get a snip in order. But I'm not, it's incumbent upon the party that's producing the materials, if they want to redact, and the court rule doesn't allow for redactions, to either file a motion or get a snip in order. Same thing with costs. Sure, they can ask me to pay it, but I'm not going to. I'm not going to as a general thing, because the problem is this. They're raising revenue through the initial imposition of costs for discovery. They then on the end, if there's a successful prosecution, also bill under 769.1F and 769.1K for the various other costs. They're double and triple billing in many instances, and this has become a lucrative revenue generating device.
Well, let me clarify something. So, I don't even know what the costs are for the discovery, none of that, or whatever you're indicating the police charges. I don't even know what it is. I don't know if it's considered reasonable or not reasonable. That has not been brought before this court, to determine. I also, will note that I have not, in my time on the bench, seen an invoice from, any of the prosecuting authorities or the police departments for collection of costs from this court, whether it's through fines and costs assessed or whatnot, for what it is you're speaking of. But what I am going to note is this. I am going to have everybody come back so I can do a little bit more research than what I have done up through today, based upon what the arguments have been so far by counsel. I will note, so what I'm going to do is I'm going to give you a new date to come back. I'm going to have Ellie email that to you with a couple of different options tomorrow. And then we'll do that. Counsel, I do want to just touch upon your memorandum regarding the Fifth Amendment right that you asserted.
Ellen, I don't know what this case is even about. But it's probably something like a speeding ticket. Like all of this effort, all of this passion and pomposity
Okay,
over,
hold up.
like, I don't know.
What if it's actually a minor theft case and his attorney is trying to get something without paying for it.
I don't know.
That would be awesome. I'm sorry.
Yeah.
I love irony, and that would be like amazing.
Right?
If this guy's getting hit for like shoplifting or something, and this attorney wants this information but doesn't want to pay for it while his client is being accused of taking something without paying for it.
Right.
That would be awesome.
And it would be surprised me.
I missed
Thanks,
that.
Tammy. I'm sorry, Poots. I didn't hear what you said.
It wasn't important.
Okay.
You
Fine.
said it. It's important. Say it again.
I don't even remember what it was now.
Okay, fine. Never mind.
That was like 5 seconds ago, Thor. Stop having expectations.
That was at least three drinks of schnapps. I apologize.
Right.
No,
Only-
one.
One big one.
It's just, it's a big glass.
Okay, cool. Understood. I get
I'm
it.
envisioning like one of those giant like Gatorade coolers just full of schnapps. There's Mima just like under the tap, like, give
Right.
it to me.
No, you
And
saw Johnny Depp's Mega Pint. It's one of them.
Okay. Mega pint. Got it.
Well, Tammy, thank you very, very much for the $5 bitch slap from the judge to this guy.
Thank you, Tammy.
Oh, can I deliver it? Can I deliver it, please? Oh, please.
Yes, you may,
Yes.
Poots, as soon as you're
Yes.
below legal limit to drive.
Yes,
Okay.
Okay. All right.
of course.
Because we don't need to be covering you on this channel.
Right. Let's not do that.
I don't know. I can be a barrel of fun.
I bet you would.
No, officer. Of course I'm not drunk. I've just been drinking.
All right, let's see where this goes. It doesn't seem like there's too much time left on
Okay.
this. But yeah, I mean, like maybe he is just inflating his billable hours.
Right.
I don't know. This is and yeah, I did catch someone said in the chat that they heard it was a misdemeanor. I don't know.
Okay.
Honestly, I have no recollection at this point. There were so many words.
Too many words.
There are too many words.
His inflatable billable hours to go with his inflated ego.
Yeah.
There you go.
Sounds like that. Yeah,
Mhm.
absolutely.
Perfectly said.
Right. All right, here we go.
Yes.
I'm not going to go into too much detail right now. I can address it again, although it was not quite correct the way you stated it on the record when you were last here. You stated that the judge was removed from the bench because he asked the question. That was not quite accurate. The judge was suspended for 30 days based upon behavior of the judge in interactions with the attorney. So
Okay.
I'm just
I also provided the other case law.
I'm just indicating the correction on that. So I'm going to have you all come back. It'll probably be in a couple of weeks or so. So Ally will communicate that date to you. Okay,
We
because I did not realize the time
Oh, that's.
that it is currently. So, and I want to do a bit more research because there's clearly competing interests in this regard, and discovery is available to both sides. And I want to make sure that with the amendment of the court rules that everything's being complied with.
We are currently scheduled for November 5 already.
And what are we scheduled for on November 5th?
Take
Oh,
things
the
up.
adjourn, yes. Okay, so let's do it. We'll just continue on that day.
Okay,
Okay,
Thank
at 2:00.
okay. I'll
Okay.
see you then.
All right, thank you. Have a good day. All right, and then let's go off the record.
Well, all right then. So that was that.
Well, what was that?
I don't know. We're gonna come back on what, November 5th and allow him to bloviate some more? I
Yeah.
don't know.
Pronounce that bloviate.
And I'm with you, legal fiction. I don't know if I want
Yeah.
to follow up on this case.
I know,
Just because
right?
this guy is
Yeah,
wow.
no, I don't. No.
No.
No,
No.
no.
And I'm pretty sure Judge DeSanto doesn't really want to follow up on that either.
I mean,
Oh,
okay, so
wow.
all of that for what? Them to come back and if you want it, go get it.
Yeah.
Right.
I
Yeah.
mean, or yes, you have an obligation to provide it to him, so get that taken care of. I mean, that's really all it's going to be. She is just going to figure out if Mr. Whiny Pants is going to be forced to go get his own damn discovery, or if, you know, the babysitter at the other table has to go get it for him because he can't be trusted with sharp objects.
Right.
know
And
what's
Sherry
right.
B, we don't either.
Yeah,
So,
it's going to be boring.
you're not alone.
Yeah,
We're all
Sherry, no.
together in this.
Yeah. 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 No, none of
Oh,
us
gosh.
do. All we know is the defense attorney is a whiny, cryy baby.
Right.
That needs his passy and his bacon and a timeout.
Yep. And a
Right.
Snickers. And a
And maybe a Happy
And a
Meal.
Nuggies, yes. But he doesn't get
Oh,
the toy till
chicken.
the nuggies are
He
gone.
no. Right. Yeah. I don't know. I mean, I don't know if he deserves the toy after that
Well, that's
Oh,
display.
hell no, I'm keeping that toy. That little sucker ain't getting nowhere near it.
Yeah. Okay. So he can have
Mila's confiscating the toy out of the Happy
Yup.
Meal. I love
So
it.
he can have McNuggies, but Pootsy gets the toy. Got it.
Yes.
No,
He
Alan,
gives
he
to
can't.
to the little baby standing next to him, going, "Here, honey, you're way more grown up."
Yes, Cheryl. Yes, I agree. Cover the outlets, bumpers on the corner.
Right?
Did you lock the fridge?
Oh, this is why we sometimes can't have nice things, people.
Mhm.
So, you
Mhm.
know. All right. Well, that's what we got for tonight. So I think if you guys recall, Colin did mention last night that he was probably not going to be able to stream tomorrow through Monday, but I did reach out and say, hey, you know, we could maybe do it for you. So that is the plan as of right now, that we'll do the stream on tomorrow night, Friday, and Monday for Members Monday, but we'll kind of take Sunday off. So we'll see. And yeah, I don't know what's going on, grammar school. You're like doing the whole like speaking only an emoji thing. So I mean, I'm interested. I'm trying to
Oh,
piece it together, but where do we
and
start?
you did that once before, Jedi. You
Oh,
only
I've
spoke
done that
emojis one stream, at least one
100%.
stream. Yes.
But in my defense, I was also a little looped. So
Yeah,
I felt like
but
the emotes just did better. So, oh, you didn't realize there's so many. Yeah, there are.
I also want to mention while we're here and talking about him, if any of you want to, our good friend Grammar here is going to be going live. It looks like in about 9:10 p.m. Eastern time. At least
Oh,
that's
okay.
what's on his channel. So I would like to encourage everybody here at Coolin' with Colin to please go visit our good friend Colin. It's usually a pretty good, or Colin, Grammar.
Grammar school.
Yeah, you're at Colin's. Just go visit Grammar.
Yes.
It's a good time.
Yes.
Wait a minute.
100%.
Yeah.
I got a
Yes,
question.
Mima. Mm-hmm.
Is what exactly is Bill Navarre saying here?
Colin, I have no idea why your channel was taken down.
He's implying, Pootsy, that we are going to get Colin in trouble with our shenanigans.
I do believe he's implying that we're not good people.
No,
Okay, Bill,
he's
he's
spot
implying
on.
that we're trouble.
We are trouble.
And we are trouble, to be fair. But
Yeah. I mean, I'll
But
give
Bill-
you that.
Bill, I would like to refer you back to a little bit earlier in the stream. Plain English, just say it. Words are our friends. You girls are going to get the channel taken down. Be careful.
All right. Well, yeah, you guys definitely go check out
Yeah.
Grammar School. I would raid if I could. I can't because I don't have the YouTube studio powers to set up a raid. But definitely go check out Grammar School. It's a good time. He has lots of fun, a little bit more on the body cam video side,
Mhm.
but it's a good time over there. So
He's
check
kind
it
of the
out. I
pre.
think,
Yeah. He's the
go ahead.
prequel to Colin.
Yeah.
I just
Yep.
want to say thank you for this chat for putting up with us because none of us knew what was going on in the video, but we all had a good time.
Right.
Yeah. Yeah. We got through. We got through.
We got through it,
Group
flying
effort.
by the seat of our pants, but we
Group
got through
effort.
it.
I would like to especially thank Rob Door Law because without you, I think all of us would have been way more confused than we were.
Absolutely.
Yeah.
And Uncle
Yes.
Dan.
And Uncle Dan. Thank you, Uncle
Yes,
Dan,
and
as well.
yes, because Uncle
Yeah.
Dan broke it down into layman's language there.
Hell yeah.
All the damn evidence.
He did say the word aggrieved. I mean,
Dan,
he's
kinda
cashing in
burned
on
it there.
words. He's cashing in on
Yeah,
words.
yep. Well,
That's
you know,
okay. You know what?
he paid a lot of money to know what
He
those words
did.
mean, so
He
he gets the
did.
right to use them.
We're gonna let them cash in,
Yeah,
Oh, yeah.
absolutely.
Whenever they want to, you know what? If we ever get back to having our Discord discussions, Uncle Dan, Mr. Rob, y'all feel free to cohort together.
Hell yeah.
Oh, yeah. Yeah. And yes, Cheryl, we did. Yes, Legal, I did.
Yeah. Yep.
I own my own.
All right. Well, thank you for all the mods tonight. We appreciate it. Your help is truly, truly, truly needed and tremendous. So thank you. Again, Grammar School going live in what, about 15 minutes?
Yeah, about
So
that.
check him out.
Yep, I just put his link in the chat.
Awesome. So go hit that. Well, okay, that came out weird.
I don't think his wife would appreciate it. And
Yeah, probably not.
I'm not
Don't
going to
do
do
that.
anything she won't appreciate.
Right. So yeah, but go visit Grammar School. Tell them we said hi. I'll probably be over there. So, and then I think somebody threw the Discord link. You can also find that in the description of the video. You can feel free to head out there and join the lounge and see who's around and chat it up. So thanks everybody for joining tonight. Any closing words for us, Stewardess Therina?
Thank you for flying with Coolin with Colin. Please remember to pick up all your trash and discard it in the bins located just outside of each and every exit. Before you disboard, please remember there is a stream that will be starting soon at our good friend Grammar School. If you haven't yet, please hit like, subscribe, and turn on notifications. Do those jump kicks and those backflips, but don't hurt yourself with a walker. Have a good night, and we love you.
Love it. All right. Well,
Okay.
with that, I think
Be
we're
able
going to
do that
say,
when I grow up.
I know, right?
What?
I want to do that when I grow up.
Yeah.
All right. Well, we have Midwest goodbye this enough. So
Yes.
we're gonna head out and so okay, bye.
Bye.
Bye.